Federalism, which is the foundation of Indian Constitution, can be referred to as the Indian government structure itself. India has a federal system of administration and has been a unified country for almost 7 decades. The separation of powers between the center and the states is an essential aspect of federalism. The goal of the federal system is to protect and promote unity while still accommodating relational variety. Even before independence, there were agreements on power sharing. The geographical and linguistic variety was recognized by leaders while debating the legislative competence of parliament. The Constituent Assembly of India gave the judiciary the authority to halt unconstitutional legislation. If the legislature produces legislation in color or disguise on a subject without having the requisite competency to make laws on that subject, the Supreme Court has the authority to annul the entire statute. When the ability of certain legislation to pass a particular law is called colourable legislation arises. It questions the correctness of adopted legislation in relation to the legislative body that appeals the law and examines whether the legislative body has the authority to make law on that subject or not. So we were discussing here about the doctrine of colourable legislation, which is based on the maxim quanto aliquid prohibitor ex directo prohibitor et per obliquum. Pronounce it in the way you want or in the way you think is right. Or you can ask any teacher or professor you have. Nor I am a resident of Vatican City, and nor I ever was. So I don't speak in the language Latin, and also that no country or state currently exists which uses the word Latin. But I'm referring here to Vatican City because Latin is considered the official language of Vatican City, which is kind of strange because no other country or state currently exists where Latin is used as a mode of communication. Anyways, bear with me. So we were discussing about the doctrine of colorable legislation. The Indian Constitution does not expressly mention the doctrine of colorable legislation. However, Article 246 has separate subjects for lawmaking. In these three lists, under Schedule 7 of the Constitution, List 1 Union List, List 2 State List, and List 3 Concurrent List. It has segregated numerous subject matters. Each subject matter is associated with either state, center, or both. For example, if in Union List use of army has been bestowed upon the central government, the state government cannot claim upon such rights. I think you can see that why we are considering Article 246 to be the most closest article to the doctrine of colonial legislation. So let's dive a bit deeper with the help of landmark judgments. One of them is K.C. Gajapati versus State of Odisha. In this case, the doctrine of colonial legislation implies that whatever is prohibited directly is also prohibited indirectly. This was intended to bar the legislature from doing something indirectly, which has been prohibited from doing directly. The Odisha State Abolish Act of 1952 was enacted on 23 1 1952 in the state. The fundamental goal of the concerned act was to abolish all zamindaris, other proprietary estates and interests in Odisha, and after eliminating such intermediaries to bring landowners into touch with the state government. Dissatisfied with the terms of the adopted legislation, the estate proprietors filed 6 challenges before the High Court of Orissa using Article 226 of the Constitution. The petitioner was filed to challenge the constitutional validity of Odisha Estate Abolish Act of 1952 as a whole. However, the matter was dismissed by the learned bench of Odisha High Court. Aggrieved by the dismissal, the petitioner have filed another appeal under Article 132 and 133 in the Honorable Supreme Court, asserting the validity of the State Act being violative of the Constitution of India. In R.S. Joshi versus Ajit Mills 1977, the Supreme Court observed that in the statute of force, the culpable exercise of or extortion on administrative force or misrepresentation of the Constitution are articulations which only imply that the Assembly is clumsy to authorize a specific law, albeit the mark of competency is stuck on it and afterward it is culpable enactment. State of Bihar versus Kameshwar Singh. The Bihar Land Reforms Act 1950 was enacted with the aim of removing the landlord's custom from the state. The state gave half of the areas of rent due as compensation to the landlord. The compensation for property acquired comes under Concurrent Entry 42. So here it was to be determined whether the act was for a public purpose or not. Judgment. The Supreme Court ruled that rather than calculating compensations, the act attempted to remove the petitioner from his property without compensation. In actuality, the act attempted to establish a principle for deciding compensation while implicitly depriving the petitioner of the right to seek compensation. As a result, the act was declared unconstitutional. Limitation of the doctrine of colonial legislation. This doctrine will not work on such instances where legislature has no constitutional limitations. It is not applicable to subordinate legislation, and doctrine of colonial legislation is not concerned if the law is relevant or irrelevant. The presumption is always in the favor of constitutionality of law, and the burden of proof is upon the petitioner.